Hello, this is Paul Callaghan. I'm the Head of Employment and Pensions at Taylor Wessing. Welcome to our webinar. I'm very conscious that North American companies can be intimidated when they look to set up in Europe and deal with different European countries. It can seem onerous dealing with the various immigration rules, the employment law rules, and you hear horror stories of some countries where it seems to be impossible to fire people once you've hired them. Well, today we're going to be taking you through at least the hiring side, just so that you can understand some of the key differences between being in the US or Canada and being in Europe. Although we're talking about Europe generally, today we're going to focus on the UK, France and Germany as the largest jurisdictions, although in future webinars we may well be touching on some of the other European jurisdictions. Just to give you an overview, we're going to start by talking about immigration. Immigration issues are often what you need to deal with at the very beginning. Then after that, we'll be talking about some of the basic employment law rules that apply in different countries. Nearly all European countries have to deal with, include employment contracts as a matter of right for all employees, and different rules essentially apply to each country. So there are some overarching EU rules, but at a very basic level when it comes to hiring and firing, the rules change from country to country. Almost as important as the law is knowing what's culturally common. So we're also going to be talking about some of the rewards that employees in Europe either are required to have as a matter of law, or where it's common or customary to have, and how you deal with those. But I'm going to hand over now to Charlie Pring. He's going to talk in general about immigration in EMEA, and he's going to focus in particular on the UK side.
So hello everybody, my name is Charlie Pring. I'm Senior Counsel in Taylor Wessing in London. I'd like to talk about how to hire non-European talent across Europe, but starting with the UK. The importance of immigration, as you'll all know, is that with a shortage of talent in different sectors, finding the widest possible tool of staff for your workforce is crucial, and global mobility is now an essential component of every North American business. Now, the good news about hiring across Europe is that you can hire anybody from the European Economic Area, and that's the same for France, Germany and the UK. So that's about 30 different countries. Anyone who holds a passport from one of those countries can work freely in any of those European countries. But non-European nationals have different rules. So although we have a one-size-fits-all if you're a European citizen, each European country has its own set of immigration rules that non-Europeans have to comply with. And that generally means that a visa is needed if work is planned. And we'll come on and look at exactly the distinction between business and work. And what I always tell clients is to think about the lead-in time to arrange your visa if one is needed. So immigration is a gateway issue for North American companies doing business across Europe, but it's often something that is left until the last minute. Visas can take weeks, sometimes months to arrange, and so it's often the first thing you should think about if you're doing business in Europe, and particularly if you want to send your first people over from North America to Europe. So looking specifically at the UK, planning early, as I mentioned, is essential. It's the first thing you should think about doing. But one of the key questions to think about if your workforce is coming to the UK is to ask the question, are they visiting the UK for business or are they actually working? And the distinction is sometimes difficult to see because there's a grey area, but in principle, where you are doing productive work in the UK, so work you'd otherwise need to hire somebody for, almost certainly you need a visa for that, even if they're coming for a short period. And we don't have a grace period in the UK that allows you to work for a few weeks before you then need a work visa. You'd need it from day one. Some non-Europeans need a visa even to visit the UK. So if you're an Indian citizen, Chinese citizen, Russia, for example, some higher risk countries, you have to have a visa before you travel, but US and Canadian citizens can travel freely for short business trips. Now, if you're setting up a business for the first time in the UK, so you don't have a presence at the moment, so send over one person. There's a visa called the sole representative visa, which is allowed for a senior employee who's going to set up and run the UK office. For businesses that already have a trading presence in the UK, generally speaking, there are some other alternatives, but generally speaking, we're looking at having a sponsor license and Tier 2 work visas, where the UK office will sponsor the work permits of your non-European hires. And intra-company transfers for your employees of your parent company or your HQ company with at least 12 months service are the easiest and fastest to arrange because there's no cap on numbers and there's no government interference at the moment anyway, so you can arrange those quickly. On the next slide, I'm not planning to speak to it, but just for your takeaway, you can see some general conditions to get sponsored work permit visas. Tier 2 ICT means intercompany transfers from overseas offices, and Tier 2 General is for any other external hires. You'll see that there are minimum skill levels and salaries for all of these visas, and also the different lengths of visas. But in principle, you can get up to 5 years initially. Intracompany transfers don't lead to permanent residency, whereas the other category, Tier 2 General, does. And with that, let me hand over to Marcus Assoff, who can talk about the French position.
So, hello, my name is Marcus Assoff. I'm an employment law partner in Paris, and I would add some sentences to what was said by my colleague Charlie in London regarding the French immigration situation. As said already by Charlie, nationals of third countries, so the other roughly 30 countries in Europe, must obtain a work authorization before starting work in Paris or in France. As said by Charlie, in France it's the same. You should plan early because it takes a couple of months in France sometimes to obtain a work authorization. What is interesting in France, there are I picked out, there are a lot of different visa types, but I picked out specifically two types of visa due to the fact that for the European Blue Card and the employees on assignment, the intergroup mobility of employees, the employment situation is not applicable. This would mean that without checking if a European or a French citizen can do the work, you can simply obtain the visa if you fulfill some conditions like a remuneration, which I mentioned in my slide regarding the European Blue Card or the intergroup mobility. It is quite easy to obtain specifically the European Blue Card, which is valid for 1 to 3 years, but can be renewed. The family can accompany, of course, the worker, and the only conditions to be fulfilled is mainly the remuneration. So, and you need also for this diploma. Regarding these are the main advantages of the two visas in France, which are quite easy to get. You just have to plan it early, a couple of months prior to the moment the person would like to start to work in France. And I would like to hand over to my colleague in Hamburg, Germany, to continue with the German immigration situation.
Thank you, Marcus. My name is Jonas Warnken. I'm an associate in the Hamburg, Germany office of Taylor Wessing, specialized in employment law. And as both of my colleagues said, the situation in Germany here is quite similar than it is in the rest of the European Union, meaning that you may hire anyone who is the citizen of the European Union, Iceland, Liechtenstein, Norway, or Switzerland, those people do not need a work permit. And as Charlie mentioned earlier, citizens of the US and Canada do not need a visa to be traveling to Germany. However, they will need a visa and work permit if they are planning on picking up work for a longer period of time, and this would take about 3 months to obtain. So again, this should be planned earlier ahead. And as Marcus just mentioned, the easiest way would be to obtain a European Union blue card, which allows you to pick up work in Germany and which can be applied for by either academics or such employees being employed in the field where there is a shortage of skilled workers. And furthermore, they only need to earn a salary above certain thresholds, which changes each year, but is roughly the same as it was mentioned for France. And the other possibility would be to send employees here for a short period of work, up to 3 months. This application is rather easy as well. Thank you, and I would like to hand over to, I think Paul is next one, correct?
Yes, it's Paul Callaghan again here. So once you've sorted out your immigration status and you have somebody to send over, or you're just actually thinking about using somebody who is a local worker, you need to think about what you have to do to hire somebody in the first place. And although each country in the EMEA region is different, there are some key principles that apply to all of those countries. And the first one you're probably going to be thinking about is whether you can have a contractor, which might save a lot of trouble over having an employee, which of course can result in potentially a lot of different regulation. And then, in truth, the rules as to whether someone's a contractor or whether they're an employee are very similar in Europe to those rules in North America. To a large degree, it depends on control. The more you control an individual in the way they work, the more that they work for you on a full-time basis, and the more that you give them day-to-day instruction, and the more likely they are to be an employee. And calling them a contractor when they're not can have all sorts of consequences. In some countries, there are criminal liabilities. In just about every country, there are problems both in relation to unpaid taxes and in relation to people getting employment rights that you may not be aware of, and potentially accruing rights like vacation. One thing that you're probably aware of, which we'll discuss a bit more later, is that vacation in Europe is an awful lot more generous than is common in North America. Usually, I would say, ask yourself, in what way is an individual different from the way that in the way that they work from your employees? And if you can think up some good reasons, then they may well be contractors. But a contractor is not somebody who you're just trying out. They really do have to be working differently, not to be an employee. Then, to hire an employee, you do need to think about whether you're going to have a UK presence, or a French presence, or a German presence, or whatever EMEA country you're thinking about. And most commonly, that will be by way of having a subsidiary rather than a branch of your US or Canadian parent. And there are some advantages to that, partly because if you did just use a branch of a North American parent company, the accounts for that parent company have to become public in Europe, which may not be the case in North America. And also, if you want to do business in Europe, having a local entity is a way of making your potential customers as well as your employees think that you really are a part of that market, and it's more likely that they're going to take you seriously, as well as obviously having limiting liability to that particular subsidiary rather than your parent company. In North America, I'm aware that it's common for employees to only be given offer letters. In Europe, everywhere, employees are entitled to contracts of employment. Those contracts of employment vary from country to country, but you just need to be aware that because there isn't at-will employment, everybody will have some sort of contract. Often in different countries, it also needs to be in the local language, even if you have it in in English too. Background checks are often as well less common in Europe than they are in the US or in Canada. To the extent that you have them, they tend to be just relating to educational qualifications and references from previous jobs. And certainly in the UK, just to cover the UK a bit more specifically, that is the case. In the UK, our discrimination laws kick in at the hiring stage, so before you've even made an offer to somebody. And discrimination in the UK is prohibited on similar grounds to what you may be used to in North America, but sex, race, disability, sexual orientation, religion or belief, and age. And in our case, there's no cut-off for age. So it doesn't matter how old you are, you can be below the age of 40, you would still potentially have protection. In the UK, whenever you hire someone, there are immigration requirements about keeping a record of that worker's right to work in the UK. So it might be a copy of their European passport, or if they're not European, then the visa or work permit allowing them to work. As I mentioned, talking about EMEA generally, background checks in the UK are usually limited to education and past employment references. Criminal checks are not generally permitted unless somebody is working in financial services or with children. And in the UK, a written employment agreement has to be given within 8 weeks, and it will cover a whole range of issues. On the slide, you'll see reference to vacation, sick pay, which is basically short-term disability, and notice. Every employee is entitled, after 1 month, to at least 1 week's notice of termination. It gets more complicated when you get to 2 years service, and there are unfair dismissal rights. But before then, it has to be at least 1 week. And for most professional jobs, the market rate is actually 1 month or even 3 months if they're in a senior role after they've successfully completed a probationary period. And I'll just hand back to Mark if you can talk about some of the things specific to France in hiring.
So regarding the French situation, as discussed, of course, it has first to be checked that the person, the individual, has the appropriate work authorization to start to work. One good news from France compared to the UK, in any case, what I learned, I think in France, you can hire an employee even without having a legal entity. So you hire the person with a contract signed by a foreign company, even if the person works in France and is governed by French law and French social security law. So you can hire without having a legal entity in France. Regarding discrimination data protection, what we see sometimes, hiring questionnaires, if it's in detailed, it's subject to an authorization or declaration to the French Data Protection Authority. Background checks are also quite limited in France, and in normal cases, let's say, not authorized. They are only possible in some specific areas for some specific functions, like in the financial sector or for security companies in the security business. A specific situation in France compared to other countries is the collective bargaining agreement. What does it mean? Any employment in France is, of course, governed by French law and by the employment contract. And on top of this, there is a third, let's say, legal source, the collective bargaining agreement, which exists in different industry sectors. And this collective bargaining agreement, which will govern the relationship between the employee and the employer, may contain specific provisions which are on top, which are more favorable than the employment contract or law. The other specific situation in France is the fact that the employment contract has to be in French. In any case, the employment contract has to be drafted in French. There are basically two types of contracts: an indefinite term employment contract or a fixed term employment contract. A fixed term employment contract, compared, for example, to Germany, can only be signed in strict limited cases and for a limited duration, which is 18 months, and it has absolutely been written. A probationary period, to give you also a positive point for France, is now possible up to 7 months in order to test the person. And you should know for France, which is also a little bit specific, is that on top of the gross remuneration, you have to pay social charges, social security contributions, which are up to 40 to 45% of the gross remuneration. For an example, you pay somebody €1,000, it will cost you 1,400 to 1,450 euros, including the social charges. So please be aware that when you negotiate a remuneration, a gross remuneration, that these social charges have to be paid to the French state in order to finance the social security state scheme, so state system. So we'll hand over to my colleague in Hamburg again regarding Germany.
Thank you, Marcus. One of the first questions that might pop into your head when you think about hiring somebody in Germany is whether you want to hire this person for an indefinite period or for a fixed time or definite period. And in contrast to what has just been mentioned regarding the situation in France, in Germany you may hire employees for up to 2 years without the need for any special reasons for this limitation. However, this again is something that has to be done in writing, which is another good cause for issuing an employment contract. Within this 2 years period, you may extend a shorter period up to 3 times. So you may, for example, conclude an employment contract for half a year, and if you're satisfied with the performance of this individual, extend this employment contract for another half a year and then another half a year. All that is possible. Beyond this time frame of 2 years, you may only conclude employment contracts for definite periods if you have a special reason for this. Example given, if the individual is working as a replacement for somebody who is on parental leave or something like this. As mentioned before, you should make an immigration check whether the employee is allowed to work within Germany, because if the individual is not allowed to work within Germany, this does not necessarily give you the right to terminate employment. So you may end up in a situation where you are obliged to pay remuneration even though you do not receive any work in return. So this should be checked. Background checks, the situation is very much alike than in the other jurisdictions in Europe. So background checks are limited to those cases where you have a special interest in the information you want to obtain. For example, the finance sector, and also the main source of information is the job interview, because there you can basically ask any questions, even though German employees have a so-called right to lie if you ask something that you are actually not allowed to ask them. As mentioned before, employment agreements are most common in Germany. One of the reasons is that some of the provisions of employment are only enforceable if they are agreed in writing. This applies to, as mentioned before, contracts for definite periods, but also for post-contractual non-competition agreements. And the last point to mention, a probationary period is possible for up to 6 months. This means that during this probationary period, you may terminate the employment relationship, observing a notice period of 2 weeks, and regardless of whether any protection rights would apply otherwise during the first 6 months of employment, they do not apply. Thank you, and I will pass on to Paul again.
Hello, it's Paul Callaghan again here. In fact, I'm now going to introduce two of my partners who specialise in different parts of benefits. One, Rosalind Connor, is a partner who specialises particularly in pensions law, which is increasingly complicated in the UK as well as the rest of Europe. And the other is Anne Casey, who particularly specialises in stock options and other equity-based compensation schemes. And they're going to take you through rewards generally in EMEA.
Hello, this is Rosalind Connor first speaking. So generally, in the EMEA region, you'll look at a reward package and think it looks very similar to those you might see across North America. There is, of course, a base pay. There will be something about vacation. Often there are bonuses, commissions, etc. A lot of risk benefits, insured benefits. Pension is often mentioned in many countries, and depending on the role, car allowances, and of course stocks and stock options or equivalent or phantom benefits along those lines. It is usual for the reward package, as we say here, to really depend on the role, on the employee, and one particular issue is across the Europe region in particular is any collective bargaining agreements that you may have to apply. There are a lot of local rules which affect things, not least rules on taxation, which of course make some benefits much more attractive, particularly when governments take policy decisions to wish to put you in those directions. And there are some benefits where there is a minimum requirement for those benefits under legislation, as well as under bargained agreements. So moving on specifically to the UK, it is important to know that as a legislative requirement, there must be 20 days of vacation plus the public holidays, of which there are 8 in the UK. Insurance varies as to what is offered and how often. It is important to be aware that in comparison particularly to the US, it is relatively rare for insured medical insurance, largely because the UK's public medical insurance or medical provision is generally no charge based rather than contributory, and so there is little to insure, and in fact it is generally held by many employees that even when they have private medical cover, the state medical cover is very similar or at least as good. And so it isn't ubiquitous, although obviously there will be individuals who are provided with those benefits. What you'll find is UK-based employees will tend to be a lot less nervous about this issue than many others. Retiree medical cover is really not provided. Certainly in my years advising, I've come across it twice, both times from US corporations who were trying to have the same benefits internationally. Pensions have recently become substantially more complicated, in particular because we now have a legislative requirement for employers to provide employees with pension. This operates on the same automatic enrolment and opt-out basis that will be familiar to any US benefits lawyers as the same as the Affordable Care Act provisions. Everyone has to be put in the plan and they can choose to leave. What's slightly different about UK pensions is you then have to be, even if you choose to leave, you have to be put in again 3 years later, and every 3 years, presumably until eventually you give up and take the plan. This is being rolled out for larger employers first, but it is starting to be rolled out from employers who employ between 1 and 30 individuals from April this year until April 2017. It depends on the payroll reference date when it would apply to companies, but fundamentally you need to be aware that if you employ so much as one person within the UK, you will need to start auto-enrolling from some point between this April and April 2017, and it will be important to check when your date is and seek some advice about that. I'm now going to hand over to Anne, who is going to give us some details on more interesting areas of stock options.
Hello. The area of stock options is very popular with North American clients because you will often want to replicate your stock option plans here in the UK for the UK employees. There are a host of issues to consider in relation to options, but I'm just going to pick on three at the moment, and they are regulatory issues, employer social security, and tax-favoured equity arrangements. On the regulatory side, we do have to look at our securities laws in the UK, and there are certain exceptions that we can use, generally where sub-plans are established for North American listing stock plans. And these are very common. There are some other exceptions which are sometimes used, but they are less commonly used. Other important regulatory requirements are end-of-year reporting obligations to the revenue here in the UK. That is now getting more complicated because it's going online this year for the first time, which is meant to make things simpler, but I think it's going to cause some issues. The second big issue in relation to stock options is a liability for employer social security on the exercise of options. Our employer social security is 13.8% currently, and when somebody is exercising an option and has an option gain, 13.8% of that can be a significant amount if the option gain is quite significant. There are ways and means of ensuring that this liability is not paid by the employer, and in fact paid by the employee, and necessary documentation needs to be put into effect for that. And thirdly, often our clients will want to have tax-favoured arrangements, and we do have a really good selection of tax-favoured arrangements in the UK. For larger companies, larger listed companies, there's a wide range of employee plans that can be used. For smaller companies and growing companies, there's a popular plan called the Enterprise Management Incentive Option Plan, which can actually reduce people's tax rates down to 10%, which compared to sort of the average for income tax and social security of around 50%, is a very valuable incentive for employees, and is one that a lot of employees are actually looking for when they are being interviewed. So that is certainly something worth considering. So that's a very quick highlight on stock options. I could speak for about an hour on that. I will now pass over to Marcus in France, who's going to talk about the rules in France.
Regarding France, the minimum wage in France, which exists since 40-50 years, it's now €9.61 gross per hour in 2015. Germany recently has a minimum wage, but of course in France the real, let's say, remuneration is much higher. As explained, in nearly all cases, a collective bargaining agreement is applicable to the employment relationship and provides for more favorable provisions for the employee, including a higher remuneration depending on the grading and the education and the job he is doing. Paid vacation in France, we have 25 days per year, 5 weeks in addition to bank holidays, and there could be additional days provided by the collective bargaining agreement. In the difference to the UK, the pensions, there is a quite high state scheme pension scheme in place in France, and therefore this explains also the high social security contributions as mentioned before. Regarding health insurance, it's the same. You have a quite high basic insurance from the state scheme, but as from January next year, it is mandatory for all companies to put in place an additional supplementary health insurance for its employees. One word to the stock options in France, which is different, maybe different to other countries in Europe. There is a federal tax and social security treatment regarding stock options. 2 points have to be keep in mind. If you would like to benefit from this federal tax and social security treatment, please be aware that you have to set up at least a branch in France, and the foreign stock option plan should be compliant with French law. These two conditions have to be fulfilled prior to granting stock options. So I will now hand over to my colleague Jonas in Hamburg regarding Germany.
Thank you, Marcus. The German situation is as follows. So as of January 1st of this year, we also do have a minimum wage of €8.50 per hour. This is very new to Germany, and there is still some issues going back and forward, but €8.50 is the situation as is. Minimum vacation is 20 days per year, calculated based on a 5 days working week, so 4 weeks per year. This does not include public holidays. The public holidays range from 9 days in Hamburg, where I work and live, up to 13 days per year in Bavaria. And it's very common to grant some additional days on top of those statutory minimum vacation days. So everything between 25 and 30 days in total is considered to be standard in Germany. Something to bear in mind, and what has been mentioned with regard to France before, is that on top of the base salary, there are social security contributions, which in Germany are approximately 25% for employers, 21%, pardon, for employers, and contributions which have to be paid by employees are being withheld from the base salary and directly paid by employers to the respective authorities. This is a service that is usually done by payroll companies. Concerning healthcare, the system works differently than it does in North America. So employees do have their own healthcare plan, which they are a part of and have a contract with a healthcare provider, and they, so to say, bring this healthcare plan into their employment, and this plan is financed via social security contributions. And the level of this statutory healthcare system is comparably high. So it's very uncommon to offer additional healthcare as an employer. Usually there is nothing further offered. Pension, it is possible to offer additional occupational pension schemes. This is done quite often, even though it is rather complicated in detail, but this is done. Special attention should be given to variable pay if drafting an employment contract. So it should be avoided to simply use a plan that is used for North America and use this plan for German employees, because German employment courts over the past years have become very strict regarding any flexibility clauses in such plans, such as clawback clauses. And they tend to say that whenever the employee worked for something, the employee earned it, and this may not taken from this employee. And they're also very strict with regard to provisions that say that a payment is made voluntarily. So this is something that should be drafted very carefully. Thank you, and I will pass on to the UK again.
Hello, it's Paul Callaghan again here. We are running out of time, so we don't really have any time for questions. So if you do have any questions in relation to any of this, please do just email us, and we will get back to you. And we'll get back to you on those. So, the key points to remember, the key point can really be summarised by planning ahead and taking advice early. That's the key to all of this. Bearing in mind that if your employees are not European nationals, they will need to get some sort of work permit, and that can take some time. Your employees are going to have employment agreements, and although our next webinar is going to deal with the firing issues, early on at least, that need not be particularly onerous if you get the right agreements in place. One thing we didn't mention, but is on the slide, is do make sure you get locally compliant confidentiality and non-compete agreements, because your US agreements won't work. And in some European countries, France and Germany in particular, you usually need to pay the employees for the period of any restriction. Do think about using consultants or contractors, but don't just assume you can do that as an interim measure. And be very careful about stock options. You can offer stock options in any of these countries, but there are quite significant tax implications if you don't do it properly in accordance with local law. So I hope you found that useful. As I say, we'll be very happy to take any questions offline. This is the first in a series of webinars under the title of Your EMEA General Counsel. The next one is on April 29, which will talk about the firing issues, which obviously can get more complicated. And then you'll see on that slide a list of some of the subsequent webinars that we're planning to hold. Needless to say, if there are any other topics that you would like to hear about, we'd be very happy to help you. So again, thank you very much for joining us, and I hope you found this useful.
Ladies and gentlemen, thank you very much for joining our session today. This will conclude our webinar for today.